Mr. Massey.
My Lord, before the short adjournment, I promised 2 minutes, and I've waited more than 2 minutes. I was going to just note, in answer to the point, or support for the point, if HMRC are misinterpreting their concession, the answer will be wrong. You can't prevent a taxpayer from relying on the concession as properly interpreted. The authority I was going to go to was a case called Cameron against HMRC. It's at authorities 27, and the point is at 501. It's page, it's page 501 of the authority. And it is the passage marked on that page. 501 on that page. And it's essentially saying to the judge, Mr. Justice Wynne Williams, in this case, the defendants argue that even if the broad concession was published in the Blue Book and if properly founded in an expectation upon which the claimants relied, they shouldn't be bound by the concession once they've written to the claimants denying the existence or application of the broad concession. This point is relied upon, particularly in the case of the second claimant. Instinctively, I don't consider that can be right. The taxpayer legitimately relies upon a statement made by the defendant, which is contained within a document published by the defendants, and aimed at the class of taxpayers of which the taxpayer is one. It does not seem to me that his reliance upon the document ought to be regarded as unreasonable, simply because an employee of the defendant expresses a view which is contrary to that construed in the document. In my judgment, the taxpayer is entitled to rely upon a statement made in a formal publication, unless and until the statement is revoked, withdrawn, or altered in the manner described.
Is that dealing with quite the same point? I mean, if the revenue's submission is that practice can affect construction, that's not obviously what's being addressed here, is it? That's
no. The point it's a point that I'm making really in answer to the revenue's point, that they can't, by their own practice, correct or make valid a misinterpreted practice. And even if, as in this case, a letter is written to the revenue saying, can you confirm that there's no question of any limitation, the answer comes back, no, there is. You're not, it's stopped. That doesn't stop the taxpayer from relying on the concession properly interpreted. Otherwise, it would be a case of the revenue becoming the arbiter of their concession, the arbiter of the interpretation of their concession. Paragraph 21C of the respondent's notice states that commentaries in practitioner texts may well include comment on how HMRC apply the concession. And again, the answer to that is that commentary on how the revenue have in practice applied a concession can't possibly be made to the construction of the concession, interpretation of the concession. If they've been applying it wrong, then that's just proof that they've been applying it wrong. Report of that practice in a book won't make it right. And I have to say, neither of the books that are in the bundle do contain any apparent reference to a long-established practice by HMRC. And then paragraph 21D, the last point, states that the judge should have had regard to the fact that HMRC had operated ESC B18 for many years in a consistent manner that imported the 6-year income limitation into concession 2B, and that there had been no challenge to its operation on that basis. The answer again to that is the judge certainly made no, he was careful to make no finding of any practice. He referred to it as the asserted practice. And in any event, if it wasn't known to the public, it couldn't affect the construction of the ESC from the perspective of the ordinarily sophisticated taxpayer. So there would have to have been some practice in existence at the time, which somehow the taxpayer was, the person in 1999 would have been well aware of. There wasn't. My Lord, that's it. No more. No further.
Thank you very much. Ms. Latham.
Thank you, my Lord. Ladies. starting point, my lord and my ladies, is this, that we are here, and I'm grateful to my learned friend for going through the relevant cases about how to construe extra-statutory concessions. However, I do feel that there are one or two, perhaps, that I ought to just remind the court of. It's been a long time since 10:30 this morning, so obviously the test has to be applied, is one of an ordinarily sophisticated taxpayer. Quite what that involves, one doesn't know. Even the Supreme Court in Davis was in disagreement as to what is to be attributed to an ordinarily sophisticated taxpayer. You'll remember the difference between Lord Wilson's approach and Lord Mance's approach, I think it is. What we would say an ordinarily sophisticated taxpayer would do is to look at the four corners of the document, look at them in their context, try and understand its purpose. We've set all the cases that substantiate this point within the skeleton argument, so I shan't take you through those right now. But he would also know that extra statutory concessions are justifiable, and this is Wilkinson, only where they facilitate the overall task of tax collection. And although it's in the skeleton argument, would it assist you, my lords and ladies, to go to those two passages, or there are two or three passages, but they are in Wilkinson in the Court of Appeal and the Supreme Court?
I think we might as well. I don't suppose they'll take very long.
No, they won't. And in fact, I might just ask you to read them to yourselves, so it'll be even quicker. So it's in the first bundle of authorities. It's a single bundle, but I seem to have it split into two. And the first is the Court of sorry, forgive me. It's Court of Appeal is at tab 19, and it's in the speech of Master of the Rolls, and it's paragraphs 45 and 46, which is at PDF 326. Might I just invite you to read those to yourselves?
Yes. Seems slightly tricky, this, in this sense, that the concessions that we see in ESC B18 aren't really, on the face of it, about trying to collect tax. They're about affording concessions where that logically fits within the tax scheme. And yes, as I understand it, it's common ground that they're intra vares.
It's common ground that they're intra vares, and in fact, they've been acted on in that way by both parties. 6 years of credit have in fact been given to the UK resident beneficiaries of the non-resident trust involved. The reason we say that they are intra vares is because they fall within the collection and management duty of the revenue. Part of which is to ensure that the tax system operates appropriately, so that income is taxed once to the extent possible, and that any infelicities that arise or loopholes that arise are dealt with. That can be by way of legislation, that can be by way of extra statutory concession, where legislating would be too difficult a task, require disproportionate effort, those sorts of things. And in fact, if I could just take you to Lord Hoffman as well, in Wilkinson, which is behind tab 20. But the idea is that they are part and parcel of and intended to ensure that the tax system operates appropriately, so that there isn't that there aren't blips where where there's double taxation, or there is an unanticipated, unintended freedom from taxation.
Yes.
And if I could just invite you to go to the next tab, which is in the House of Lords, as it then was, of the same case, Wilkinson. and to paragraphs 20 and 21, which are at PDF 336 and over the page to 337. And this is where points about pragmatism and the like will come in as well. Might I please ask you to read those to yourselves? And might I also invite you, my lord and ladies, to turn up ex parte MFK, which is at tab 15 of the bundle. And the relevant passage to which I'd like to take you is really starts at the bottom of page 1568 at about F and goes over the page to about just above H. Might I please ask you to read that to us?
Yep.
Thank you.
The last part of the highlighted section is about legitimate expectations.
Yes, no,
you
not
weren't
correct.
intending
No,
to.
no. The only point, the reason to take you to Wilkinson was to remind us all that ESCs are there to ensure collection, ensure that the tax system operates properly, and to take you to MFK to show what it is that an ordinarily sophisticated taxpayer would expect of the revenue.
Is this the origin of the ordinarily sophisticated taxpayer, or had the expression a longer history?
Well, I did some research on this, and in the tax context, this seems to be the first time that I've come across it. I couldn't find an earlier iteration of this. In a non-tax context, one sees references to a reasonable reader and the like, and absifer is that sort of case. But yes, I mean, I did look to see exactly what is this ordinarily sophisticated taxpayer, this fabulous, almost mythical creature who knows everything and yet is also looking out for his own interests. And that's as far as I can take it, I'm afraid. The other thing that I would like to point out, and again, it's in our skeleton argument about bright lines, that it's perfectly permissible for legislation, ESCs, practices and the like, to have bright lines. Policies can decide this far and no further. This relief will apply here and no further. And you will see in the skeleton argument that we've referred to Accenture, Azora and Tigre, if I've pronounced it correctly. And if I might just perhaps trouble you to go to Tigre, passages at 36 and 37, so that's PDF 596. Which will be, I think, in the second bundle. tab 29. I mean, the factual circumstance is different, of course, because a student looking for a student loan, having come here from abroad, having been brought up here, query what was settled intended to mean in that context. It had to be somebody who had indefinite leave to remain and the like. So the context is slightly different, but there was a bright line rule that, in effect, they needed to have indefinite leave to remain to be regarded as settled. And the court was discussing whether or not that was an appropriate test and whether it was an appropriate test in this case. And so if I could just invite you to go to paragraphs 36 and 37, which are to be found at 596, as I said, and
would you like us to read this?
might I please invite you to read that? And that was just to take you to a proposition, a case that supports the proposition that bright line rules are perfectly all right in principle. And then the question is, are they appropriately bright lined? Are they appropriate in a particular circumstance? If I might then invite you to go to Greenwich, which is at tab 17. And that's with two propositions, so it's good value for money, as it were. The first, so that's Greenwich property. This was a case where there was student accommodation, which was then let out by a wholly owned subsidiary, I think it was, of the university in query. Did the relevant VAT treatment, which had been agreed between the revenue and the university, apply in that circumstance? It was the revenue had said it didn't apply, and the court asked, well, why on earth not? And it was as part of Mr. Justice Collins's reasoning. I invite you to go to paragraph 13, where he sets out the certificate that was relied upon in something called peculiarly a concordat. And then at about E, one of the problems of concessions is that they can lead to documents such as this certificate, which is and is known by all concerned to be inaccurate. None of that, of course, is, I'm not saying that this is true on our facts at all, but I'm just reading down the background. The building was not going to be used solely for a qualifying purpose. Nonetheless, the commissioners were content such a certificate should be issued, provided the concession referred to in paragraph 37A was applicable. It is a pity that the trenchant aphorism of Mr. Justice Wharton in Vesti, and then he sets it out there, was not heeded. Concessions lead not only to artificiality and false documentation, but also to arguments whether particular transactions fall within them. The language of a concession is not that of a statute and should not be construed as if it was. But if a concession is published, then people are entitled to arrange their affairs accordingly. So my learned friend asked, well, what exactly does it mean if something is not a statute? I mean, it's agreed between the parties that it doesn't have to be construed as if it were a statute. What flows from that? Well, we would say that what flows from something not being construed as if it's a statute is not to be overly formalistic in the approach to reading it. While it is true that linguistic canons of construction can apply to all documents, not just legislation, one does have to bear in mind that the sort of thing that you would expect in legislative drafting, such as conditions being fully replicated in paragraphs to which they're supposed to relate, those sorts of formalities, that sort of typical technique, is not necessarily something that ought to be brought in when looking at an ESC. And then also it is relevant to look at the purpose of the ESC, the document, in order to work out what it's, to try and work out its meaning. And that, for that proposition, I invite you to go to paragraph 21, which is at page 278.
I'll read that as well.
I'd be most grateful.
Sorry, we'll read that as well.
Yes, thank you. And in our skeleton argument, we also set out Argyle House. I won't trouble you because it pretty much says the same sort of proposition. And the passage to which I took you in ex parte MFK identified that it's the taxpayer's legitimate expectation that he will be taxed in accordance with the law. And
I mean, again, there has to be some degree of qualification to that, doesn't there? Because if we take well, any of the three concessions, plainly they give entitlements that do not flow from the statute.
And that point is actually addressed in Greenwich. So it, in fact, is good for three. It's a bit like a special position. It's good for three propositions. Paragraph 23. I am prepared to accept that since the Commission was relieving a taxable person of a liability imposed by the law, something they are empowered to do by virtue of their care and management powers, and then he cites Arnold, the taxable person must demonstrate that he acted strictly in accordance with what the concession permits and has complied with all the conditions necessary to obtain the relief. Any doubt should be resolved in favour of the tax being payable according to the statutory provision, since, if there is doubt or the language of the concession is ambiguous, the taxpayer should inquire of the commissioners whether what he intends to do falls within the concession. Of course, the question of in this case, they did inquire of the revenue, what the revenue thought, and the revenue said it's 6 years. It's not that part to which I wish to draw your attention or to focus on. It is that when you have the law creates quite a strict position for UK beneficiaries of non-resident trusts, where the trusts receive UK income. This supports the proposition that if there is any ambiguity about whether the 6-year limit indeed applies to concession 2B, the strict legal position seems to be the one that ought to operate. So no relief. And that is why I took you to the strict, to the context in which ESCs are produced. They are to alleviate difficulties and felicities, fill in the interstices of the tax. That's part of what they do. They're also supposed to enable tax collection. What they're not supposed to do is to basically open up an enormous gap in tax collection. And the gap can arise in relation to non-resident trusts in two ways, only the second of which is enforcement. The first of which is that while UK trusts, UK resident trusts, are taxable on all sources of income and may be able to get reliefs for where DTAs or other such reliefs apply, and where UK trusts, which are discretionary trusts, have to create, in effect, a tax pool so that all the tax that they have paid, as it were, goes into this notional capacity, this credit, which is then available to them to frank the tax that is due from them on distributions they make to beneficiaries. Neither of those 2 points is true for non-resident trusts. So the creature itself is a very different creature. A UK resident trust is a different creature for tax purposes to a non-resident trust. Non-resident discretionary trust, forgive me, I should make that clear. Each is a separate source, and that's what Section 16, when enacted, created. A separate source of income, thereby creating the possibility that there would be tax on income coming up to the trust and tax on income coming out from the trust. And in order to address that, one had Section 17, only for UK resident trusts, and it created the, as it were, the notional pool that is available to credit against the tax liability on payment to a beneficiary out of income. But of course, that only dealt with that specific circumstance. It didn't deal with a circumstance where you've got UK trust receiving foreign income, which is not taxed in its hands because it's subject to a DTA. And that's where Section 18 came in. And Section 18 required a claim. And Section 18 required certain conditions to be satisfied. And if I might just invite you, I think it's probably easiest for us to go to the Statement of Agreed Facts and the documents that are attached to those. So if we start, say, at the statute is set out behind the relevant ESC. So if we could go to page 53, which is Section 16, as at in around 1978, because that's in relation to that provision, but it's the FA 1973. Section 16 is additional rate charge on trustees. 17 is the franking idea. There's a pool, there's the trustees can then set off their liability against the tax they've already paid. And then you've got 18, so page 55. Subsection 2 shall apply if a payment made by trustees falls to be treated as a net amount in accordance with Section 17.2 of this Act. So it relates to UK resident trusts by virtue of the reference to 17.2. And the income arising under the trust includes income in respect of which the trustees are entitled to credit for overseas tax under Part 18 of the Act, and it's defined as taxed overseas income. If the trustees certify that the income out of which the payment was made was or included taxed overseas income of an amount and from a source stated in the certificate, and B, that the amount arose to them not earlier than the year 1973-74 and not earlier than 6 years before the end of the year of assessment in which the payment was made, the person to whom payment was made may claim that the payment up to the amount so certified shall be treated for the purposes of Part 18 as income received by him from that source and so received in the year in which the payment was made. So what it does is it says that if you have, even if you don't pay UK tax in respect of it, because actually this income has been subject to relief in your hands, you can still get the credit to frank a payment that you make to the beneficiary. But it's again UK trust, foreign income.
Can you just slow down for a minute, please, Ms. Nathan, because it's almost impossible to take a note of what you're saying at that breakneck speed. Could you please be kind enough to repeat the last sentence? Even if you don't pay UK tax.
Even if the trustees of a UK resident discretionary trust do not pay UK tax in respect of foreign income,
Yes.
which they have received,
Yeah.
which is relieved from UK tax by virtue of,
Double taxation.
yes, then that tax, that relieved amount of tax is available to them to frank a payment that is made to beneficiaries.
Okay, can I just clarify how this works? Because in fact what Section 18.2 says, it doesn't appear to be dealing directly with the tax position of the trustees, which is the way you've just described it. What it says is that the person to whom the payment is made, that's the beneficiary, may claim the payment as income received by him from that source. Now, I'm assuming that the way you get to the same place that you've just described is by well, this is what Mr. Massey describes as a look-through mechanism.
Yes.
So that rather than the trustees having to pay tax on the distribution under Section 17 without having a credit, because there isn't any tax to credit, they don't have to pay tax on that distribution under Section 17, but rather the beneficiary is treated as receiving the underlying income. Now, is that fair? Was it does
yes.
take a bit of reading in, I think.
Yes, yes, and I think that is fair, my lady. That is a fair reading
Okay,
of that.
thank you.
But the effect of this, we say, was to remove one of the areas that remained problematic as a result of the introduction of the changes that meant that a discretionary trust is its own source of income. And what we would ask you to bear in mind is that this was made subject to a claim, and it set out a condition that the trustees must certify those things that are set out in sub 2. And that condition included the 6-year income limit. If we then go into ESC B18 sub 1, we see that it then deals with another infelicity.
Sorry, when you say sub what, do you mean, are we now looking at the original version of the concession?
We are looking in, I'm going to take you, if I may, in chronological order, to start with ESC B18 and 78, then 94, then 99, but bearing in mind at all times that what we're construing is 99.
Yes.
So, if we look at ESC B18 in 1978, that is set out at 52, forgive me. And we know that it deals with a UK resident trust because it refers to if a payment made by trustees falls to be treated as a net amount in accordance with Section 17.2. So that is a reference to the UK resident trust. And then it says that if, and the income arising under the trust includes income in respect of which the beneficiary would be entitled to the sorts of reliefs that are set out there, which are basically reliefs for non-resident beneficiaries in receipt of those sorts of income. Such relief will be granted to the beneficiary on a claim made by him to the extent that the payment is of the income which arose to the trustees not earlier than 73 and not earlier than 6 years before the payment is made. So, stopping there, we see that this deals with one different area that was not addressed by Section 18, which is UK trust, non-resident beneficiaries, particular sorts of foreign income. We see also in that first part of the concession the additional words. I've stopped at the 6 years before the end of the year assessment in which the payment is made. But we see provided that the trustees have submitted for each year tax returns which are supported by the relevant income tax certificates and which detail all sources of trust income arising and payments made to the beneficiaries. We ask you to note that because you find a similar condition in the next bit. And the next bit starts with a similar concession will operate where the payment made by the discretionary trustees is not within 17.2, so it's not a UK resident trust, but constitutes income from a foreign possession, e.g. where the non-resident trustees exercise their discretion outside the UK, provided the trustees submit returns, so supported by the relevant income tax certificates, which detail all the sources of income arising and payments made to the beneficiaries, and also pay additional rate tax. Now, we see that that condition is set out there. We see that the words a similar concession apply. This does not, on its terms, differentiate between the types of beneficiaries of non-resident trusts. It doesn't say it only applies to non-resident beneficiaries of non-resident trusts, or that it does only apply to them. It doesn't differentiate between them at all. Just says if you're a non-resident trust, a similar concession will apply if you satisfy these additional conditions. If you do, and we say that the conditions must, given the words are similar, import that which has gone before. And
But,
one,
sorry, just to get my head around this, I see the point. Does that therefore import that one would be applying a look-through position in both sets of circumstances?
and I was just about to come on to that, my lady. The point is that what is being, one could say that a similar concession refers to the method of giving the relief or giving the relief itself.
Right.
So, we say that the form of the relief doesn't necessarily correlate to the extent of the relief. The form of the relief may be a credit mechanism, it may be look-through relief, but what it is achieving, i.e. the outcome it is achieving, is a relief from either excessive tax or from double tax.
So if we take this second concession in the 1978 version, how do you say it did operate?
Well, we say that it operated, it doesn't specify how it operates, and but it is intended, we say, on its face, to give relief to those people who come within it. Those people who come within it are non-resident beneficiaries and UK resident beneficiaries of non-resident trusts. How that relief is to be given, i.e. the methodology of it, is not clear from the face of this document.
But a key point, and this is contrary to what is said in Justice Chamberlain's point, is that your position is that both UK and non-UK beneficiaries were within the second part of the original concession.
Yes.
With, you say, no detail as to precisely how.
What we say is, I was just about to
concessions
develop
apply.
the point, which is that if you were to stop just by looking at that small bit at the bottom of the page, you would say that, well, there's no condition, there are only conditions, but it doesn't tell you how to give the relief. Whereas what we say is, when it says a similar concession, what it's talking about is that there will be a relief for beneficiaries. To the extent that the relief can be given in a look-through way, it can be given by way of look-through. But to the extent that it can't be given by way of look-through relief, a different methodology is necessary. But what is
Reading an
important
awful
is the
lot
relief.
into the words a similar concession, Miss Nathan.
Forgive me.
Isn't it? It's reading a very great deal into the words a similar concession will operate. To say, well, you have to imply into this that it will be a look-through if it's possible to give a look-through, but then you've got to come up with some other means if it isn't.
What we say, my lady, is this, that the words a similar concession focus not on the method, but on the availability of relief. And as it was set out in, I think, the witness statement of Mr. Mark Rimmer, which was before the judge below, that the 1978 practice itself was just, I think it's at paragraph 22 of the witness statement, which is at PDF. It's in the core bundle. page 230. Paragraph 22. Was therefore introduced during 72 to address the disparity of treatment. Whilst B18 was first published during 78 as a concession, it represented a long-standing practice to look through to the sources of income, and these practices were in operation prior to 73. This is confirmed by precedent material. So the idea was that 78 created the relief that is available, undifferentiating between beneficiaries of resident and non-resident trusts.
So when wouldn't look-through have been appropriate?
It would arguably not be appropriate if what would happen is a double relief, so that a non-resident beneficiary receiving income from a non-resident trust.
Sorry, non-res beneficiary receiving income from non-resident trust.
Yes.
Yep.
Is receiving income from a foreign source.
Yes.
So he doesn't come within this unless he has UK source, unless UK source income arises to the non-resident trust, because UK source income is taxable in the hands of a non-resident trustee. So you have a situation where there is tax on that amount, which had the beneficiary directly received the amount from the UK, wouldn't have been subject to tax. In that scenario, look-through seems appropriate because that is where. But if there were to be a circumstance where there's tax paid by the trustees in respect of UK source income, and there would be tax again in the hands of the beneficiary in respect of that income, it would be appropriate for there to be a credit mechanism so that there's a franking of the two taxes.
Sorry, I'm really not following this. I'm sorry. Can we just think of an example of a type of income? So dividend income from a UK source, if received directly by the beneficiary, might well in 1978 have been treated very differently to tax on a distribution from a trust. So I think we need to be rather careful. I was asking Mr. Massey about, so what are we talking about? What's the source of income?
Yes.
What the look-through for, fortress securities or something like that is quite clear. But this is rather different. We've got UK source income for a non-resident beneficiary. It's only UK source income that we're concerned with, because other income isn't going to be, for a non-resident trust, isn't going to be bought by the UK tax system anyway. In what circumstance wouldn't they be looked through on this original version of the concession?
Put in those terms, I'm having difficulty on my feet to think of an example.
Yeah.
But the only proposition that I was seeking to draw here, from reading ESC B18 as it was drafted in 1978, was that it uses the language of a similar concession, which is true all the way through. It deals with non-resident trusts, and it deals with them without differentiating between the types of beneficiaries that it is seeking to give relief to. Our fundamental thesis is that ESC B18 is a continued attempt to provide relief in circumstances where there might be excessive tax or double tax.
Is another way of putting your point that on your approach, the concession hasn't fundamentally been extended in its later versions?
And certainly I was going to take you to 1994 to show you the press release, which was in the public domain.
Right. Okay.
Did form part of Mr. Justice Chamberlain's decision as well, because he set it out there, which shows that actually, as far as the revenue were concerned, it had always been a relief had always been available, even for UK resident beneficiaries of non-resident trusts. And if I might just move on to
just
that.
before you do,
Yes.
as to the question of look-through or not, Mr. Rimmer in his witness statement refers to look-through. He
Yes.
doesn't refer to anything else.
Yes, and I can see that from reading his witness.
So there's no apparent reason to think that anybody had anything in mind but look-through in 1978.
Yes.
Then you say, well, looking at the terms of the second concession in 1978, it's not restricted to non-resident beneficiaries, it can apply to UK beneficiaries. Now, why does that matter?
Because of the way in which my learned friend then seeks to interpret section ESC B18 2B in 1999, because he seems to draw a distinction between the way that the ESC always dealt with non-resident beneficiaries of non-resident trusts and the way that it then went on to deal with resident beneficiaries of non-resident trusts.
But if the truth is that back in 1978, everybody thought that the second concession to whatever classes of beneficiaries applied was look-through, then if Mr. Massey is right about concession 3 in 1999 being about the credit mechanism, then it is different.
My lord, it's a big if he's right. Of course, it's entirely our point that he isn't, with the greatest respect to my learned friend. But our position is this, that it's not a matter of how the relief is provided. It's more that the relief is provided. Because if you look at the statute, relief wouldn't be provided at all in any form to these beneficiaries.
I mean, I follow that, but when you say this is about whether or not relief is to be provided, not about how, somebody reading this at the time wouldn't have been much comforted just by knowing that some kind of relief would be afforded without any attempt to define what kind of relief. And one would have thought, well, he'd have said, it says a similar concession, therefore it's going to be similar to what has come earlier up the page.
My lord, and that's a fair reading. So a similar concession would be that it should be looked through, because that's exactly what the words "a similar concession" we would say import. But the importance to be attached to the look through versus the relief aspect of that is, we say, more in favour of the concession being the outcome, i.e., that you are relieved from this excessive tax. We will, and the way that that is achieved is by way of look through in that scenario. So the modality ought not, we say, to be necessarily to be tied to the fact that the relief is available. Because absent ESC B18, no relief whatsoever is available.
Put another way, you say in 1978, one way or another, relief could have been given to a UK resident beneficiary of a non-UK trust. In some manner. That was, you say, at that time subject to a 6-year time limit.
Yes, because of the words "a similar concession."
And then you say that should inform the interpretation of later versions of the concession, specifically the 1999 one.
Yes, because it's part of the context and it's part of the way that the matter itself developed. And it's entirely consistent with the purpose, we say, of the ESC, which has never changed. It has been, as I have already said several times and I shan't repeat, to provide the relief. And so if I could just invite you to look at the next iteration, as it were, of ESC B18, which is in 1994. Now, this was accompanied, it was issued at the same time as the press release to which I've adverted, and that is to be, it's set out in the judgment of Mr. Justice Chamberlain, PDF 80, page 80, paragraph 43. So this was in the public domain, it's a press release. In case it assists you, my lord and my ladies, those sitting behind me who have significant muscle memory within the revenue, have informed me that look-through was the term that was used for all B18 concessions by the policy team at the time. Make that, it is, I'm grateful to them for that note.
Yeah.
So, looking at paragraph 43, might I just invite you to read that through?
Taken literally, that doesn't apply to a situation where the beneficiary has no tax liability on that income, because there's nothing to credit.
If a beneficiary has, what this permits is an ability to make a claim. A claim could be made where, even where there isn't actually a tax liability on the part of the individual, because that could, and I think this picks up the point
I'm well aware of that, Ms. Nathan. The point I'm making is that one can't regard this press release as exhaustive of the description of the position, because it doesn't, on its face, cover a situation where the beneficiary has no tax liability on the income but can claim the money back because it's been overpaid.
Well, we would say that the ability to claim credit is sufficiently broad to cover that.
What, to set against his non-existent tax liability?
And to claim a repayment.
Yeah, I mean, that is a point on the wording of the concession itself as well, if it's there. But this is something that we say is in the public domain at 1994. It sets out what the revenue considers. Admittedly, it's what the revenue considers, but it's part of what would be the context that an ordinarily sophisticated taxpayer would have for them. And they would know that, okay, well, if I didn't think that 1978's ESC B18 was sufficiently clear, and I, as a UK resident beneficiary of a non-resident trust, am entitled to relief, I now know I am. Does it tell me how I'm supposed to get that relief? Well, let me look at its terms. And so one then goes to ESC B18 in 1994, and that's at page 56, forgive me. And you can see that it's set, now it has headings, UK resident trusts, and it's got non-resident trusts. The UK resident trust section, might I just invite you to reread that to yourselves, and you will see that it again refers to the non-resident, to the UK resident trust provision. That's 6872 as rewritten. And it again relates to a beneficiary who would be entitled to relief by virtue of non-residence in respect of certain types of income. It requires the beneficiary to claim those reliefs. And he may even claim for a repayment if that's expressed on its terms. And there's an income limit there. And there's a requirement that the trustees have made trust returns and the like. And then we see the heading non-resident trusts. And we see the words, a similar concession will operate where a beneficiary receives a payment from discretionary trustees, which is not within section 6872. So it's not one in relation to UK resident trusts, but is income which arises from foreign possessions, where the beneficiary receives a payment out of income of the trustees, in respect of which, if he'd received it directly, he would have been liable to UK tax, then he can claim the relief.
and he may be treated as if he received that payment from a UK resident trust, but claim credit only for UK tax actually paid by the trustees on income out of which the payment is made. Now, my learned friend, I think, accepts that the 6-year limit applies here because of the words a similar concession. And we say that that is absolutely right, but we do not think that it is appropriate to stop only at the one type of beneficiary that is set out there, i.e. we're a non-resident beneficiary. We say that partly having an eye to 1978 not having distinguished between the two. We say that also by looking at the opening words, a similar concession will operate where a beneficiary receives. It doesn't specify which type of beneficiary there, but the following subparagraphs then deal with the two types of beneficiaries.
Just following that through. Maybe this is a different point. In fact, I think I'll defer my question.
I'm happy to take it whenever. Mandy.
I think this goes off at a tangent, actually, but as it's in my mind, I will ask. Looking at the press release, that says the amendment ensures that the concession applies to allow UK resident beneficiaries of non-resident trusts to claim credit for UK tax paid, which is our situation. The Inland Revenue have always viewed the concession as enabling credit for this tax to be claimed. You don't, do you, suggest that actually the 1978 concession did cover that situation?
It didn't expressly state it on its face, but the understanding was that in one way or another there would be relief provided.
But, I mean, I follow that. That's what the Inland Revenue is saying. But one could not contend, could one, that the 1978 version covered that situation? I mean, assuming, as you say we should, that the second concession in 1978 extended to UK beneficiaries as well as non-resident beneficiaries, it still wouldn't apply because it's not dealing with that situation.
Well, it depends on what one calls the situation. And our thesis, which was accepted by Mr. Justice Chamberlain, was that actually what is being sought to do with all of ESC B18, and indeed Section 18, is to provide a relief in circumstances where otherwise there would be excessive or double charge. The way in which it's provided is as it were, the secondary feature. So the fact that the Revenue have always viewed, or state that they've always viewed a concession as enabling, relief might be a better way of putting it rather than credit. But I take your point about the language of it, that it refers specifically to credit. But I think, again, this is a press release. It's not statute. It is, I mean, it's even further, as it were, from an ESC in terms of quality of, perhaps without being pejorative to anyone. But yes.
Okay, we may be cross purposes. I understood the Revenue's position to be that the last part of the 1978 version of the concession is wide enough to cover UK as well as non-UK beneficiaries. Doesn't specify how the job should be done, but one way or another, you have some sort of, using it totally non-technically look through, which might involve a refund of tax that's been paid by the trustees.
We would say that subject to swapping out the word look through and putting in the word relief, yes.
Yeah. I use the word look through because you told me that that's what the Revenue thank you.
Exactly, but look through in this forum has a very specific meaning and a lot of weight is being placed on it, and hence I'm being a little cautious about things. A accepting that proposition,
I see.
we would say that while it may or may not have been the case that the revenue actually uses the word look through to refer to all reliefs under ESC B18, and my lord, you are right that where this press statement talks about credit, I think in my submission the correct way to look at this press statement is to say that what was being expressly provided for was relief to beneficiaries whom they thought were already covered by ESC B18 in 1978, but this made it express. And then but as it happens, that second part that deals with non-resident trusts with UK resident beneficiaries provides relief with a different mechanism, not the look-through mechanism, but a credit mechanism. Standing back, when one looks at 1994 even, again, this is only context, it's not the thing where actually the ESC that we need to, or the ordinarily sophisticated taxpayer needs to construe. But what this does is it leaves, as it were, the position of the non-resident beneficiary marooned. Because the non-resident beneficiary doesn't seem to have any conditions attached to the way in which his claim needs to be made. And I think my learned friend accepted that it was incomplete.
I think he says it's a point against you.
We say that the conditions are imported by a similar concession.
Well, in the 1994 version, that if you put weight on the paragraph spacing, the penultimate paragraph could be taken to qualify both.
It could be taken to
UK
qualify both.
resident.
One might say it's an abundance of caution, but weight has to be given to the words actually on the page, and the words a similar concession must have some meaning. So what is meant by a similar concession? Similar has been used, not identical, so it doesn't have to necessarily be the same modality, the same mechanism for providing relief.
Well, similar qualifies the concession rather than the modality of the concession. So it's got to be of a different, it's the nature of the concession, isn't it?
Thank you, my lady. And the concession, we say, is the provision of the relief.
Yes. Using plain English, if you are in this situation, you will get a similar relief to if you were in that situation.
Yes, which is that you won't have to pay double tax on that income, or you won't have to have or you won't be excessively charged. Say you're a non-tax-paying beneficiary. So a similar concession, we say, has to be given weight. How is it to be given weight? It is to be given weight by looking at what comes before in order to determine how it applies to what comes after. Because similar clearly creates a link between the two. Similar to what? Similar to what has gone before. What has gone before is a relief to a particular constituency, subject to certain conditions, including the 6-year limit. And that is read through, as it were, to below the heading, non-resident trusts. And the words similar concession have been there since 1978 at this point. So we know that they're intended to apply above and below, i.e. to that which is dealt with as what we call 1, as well as what is called 2, now split into 2A and B.
Yeah, the 2B bit, of course, is controversial. You don't get that from 1978.
Well, what we would say is that it's a question of modality versus the outcome. The outcome is, yes, a relief would be given. That's what 78 is saying in the second part. What it's not specifying, and on which I've been pressed, is the manner in which it would be given. And the witness statement talking about look-through, I know it's not admissible evidence, but there may be some, as it were, loose language that is used about the mechanism for providing that relief. but what was intended was that non-resident beneficiaries and UK resident beneficiaries of non-resident trusts were entitled from 78 onwards to some alleviation of their tax liability that would otherwise arise in relation to the UK income being deemed to come to them through a non-resident trust. So one then...
I'm going to confuse myself again for a moment. But, so back in 1978, when you say the second part applied to UK beneficiaries, and I can see why, as a matter of language, you can say that. What was the first concession going to add in relation to UK beneficiaries? If the second part extended to UK beneficiaries, what was the point of the first concession?
The first concession was for non-resident beneficiaries, so it's a different constituency.
And UK trusts.
And UK trusts.
Yeah, that's UK trust.
Yes. So, the very first. Sorry, I've misunderstood the question.
No.
ESC B18.
My lady has the right answer.
Yes. The first one is UK trusts, non-resident beneficiaries. B2, whether one calls it concession 2A, I've adopted the judge's terminology.
Yes.
Is UK trusts, non-resident beneficiaries.
So if you find in relation to UK trusts some specification of the circumstances and the mechanism, why should one assume nothing similar for the UK beneficiaries of foreign trusts?
Are you taking me back to 1978?
I'm pursuing 1978 for a moment.
Yeah.
Yes.
It's a natural reading that's available to you to say that it would be the similar mechanism for giving relief as well. It's definitely open there on the language.
Yes.
But it may be, and I cannot think of an example where it would not be appropriate. But I think, as my lady said, in one way or another, relief was intended to be given. That is. So it's the focus on the mechanism by which it's given, we say, is actually is misconceived. The focus really is on the fact that there's an alleviation. Otherwise, there's a 17 problem, and there's no let out for anyone unless you come within Section 18.
Yeah.
And then, if I could ask you to move forward to ESC B18 in the 1999 version, which is the thing that we have to construe. I make the same points. We see that the headings are slightly differently set out. We say that one of the points about not treating this like statute is not imbuing it with the need to conform to the sort of statutory drafting techniques that one might expect to see were it statute. I mean, clearly headings are helpful, and there are headings. There are paragraphs, but do the gaps in the paragraphs, or the disappearance of gaps in the paragraph, carry the weight that my learned friend seeks to put on them? We would say no. The presence or otherwise of these gaps has varied over time. I mean, if one compares 1978 to 1999, so with a finger in each, and one looks, say, at even ESC B1, we see it's drafted, formatted differently, but the formatting, we say, can't. And this must be what is meant by don't treat it like statute, don't construe it like statute. The words must mean what they mean, because that's the bottom line, the cornerstone of any bit of construction. But focusing on gaps, focusing on the headings or the lack thereof, we say is not to conform to what Mr. Justice Collins said was the appropriate way of trying to deal with and construe ESCB, any ESC, any concession. I think you have my point about how the words a similar concession links the first part with the second part, the first part being concession 1, the UK resident trusts part, and the non-resident trusts part. You have, I think, certainly heard my points on on concession 2A, which is the non-resident beneficiaries. There are no conditions attached to it unless they are imported by the use of the word a similar concession. We say that my learned friend's reliance on the lack of a gap between the sentence that finishes under non-resident trusts, trustees exercise their discretion outside the UK. We say the lack of a gap there does not mean that those opening words in that first opening paragraph only qualify the words that immediately follow, i.e. the wording relating to a non-resident beneficiary. And one of the reasons we say that is don't attach weight to gaps, because they don't bear the weight, absent any obvious reason why they should be different, why gaps are important. We say gaps in this context should not be given the weight they are. But we also say textually, it is clear, we say, that the opening words must qualify the position of non-resident beneficiaries and the position of UK resident beneficiaries. And we say that, forgive me, I'm going to go a bit slow. And we say that because of the opening words. A similar concession will operate where a beneficiary receives a payment from discretionary trustees. And it then goes on to describe the two types of beneficiaries. And you see the link there with the opening words of the non-resident beneficiary paragraph, where a non-resident beneficiary receives such a payment out of income, etc., etc. And then you have a UK beneficiary of a non-resident trust may claim. So that's the two types of beneficiary that are, as it were, signposted by the reference to a beneficiary and a similar concession applying to them.
If, on page 59, if the penultimate paragraph on page 59, that paragraph had been missing, just didn't exist, would it be your submission that it would be imported by the similar paragraph which appears immediately above the words non-resident trusts?
I would say that, yes, my lady, I would. The fact that it's repeated...
You have to, don't you, I think?
For consistency, I would need to, but
Yeah.
in fact, we would say that these conditions are there in order to... if that condition wasn't there, there would be... a different, there might be a non-time limited basis for making a claim. And that can't be consistent, one, with the role an ESC has to play, and two, the language of a similar concession being used. Because it wouldn't then be similar, it would be unlimited. And we say that for the same reason, a similar concession must mean that the extent of the relief that is afforded to non-resident trust beneficiaries must also be limited in the way that that ESC B1 is limited.
And when you say extent, you mean in this context, the number
6
of
years.
years.
Yes, my lady.
Can I just ask, on page 59,
Yes.
my lady has just referred to the penultimate paragraph, which is the 5 years and 10 months.
Yes.
Immediately before that, the conditions about making trust returns and so on appears on a new line, but I can't tell whether that's a paragraph break without a gap or what. Do you say that those conditions about making trust returns and so on, how do they make their way into what the taxpayer calls concession 2?
My lady, my learned friend's argument is that a similar concession, because it forms part of the paragraph dealing with non-resident beneficiaries, imports all the conditions.
Yeah, no, I want to know what your position
Our
is.
view is that that a similar concession applies all the way through. So it applies to 2A and to 2B.
Okay, so then what are we saying that this language about making trust returns and so on does?
It's an abundance of caution. Again, we say that this is not statute. It's not the sort of technique one would expect in a statute, where conditions are set out once and then imported by reference or applied by reference.
Another possible way of looking at it is if by similar concession you're getting at the guts of the thing, including the nature, and you say extent in the sense of the number of years, that is qualitatively different to the procedural hoops, if you like, that you need to climb through to get the relief. And these conditions could be viewed as more procedural hoops.
If I've understood the point my lady is making correctly, that these are additional conditions that apply to UK resident beneficiaries of non-resident trusts, which aren't imported into the other parts.
Well, no, I'm asking what your position is. Why, put it another way, on your approach, why is it necessary to spell out not only the 5 years and 10 months point, but you need to make the trust returns, you need to pay all the tax. Why is that spelled out? You say an abundance of caution.
That would be our point. The words a similar concession, we say, are enough to import the conditions into all of 2A or 3 or 2B, whichever one prefers.
And just to be clear, where we find in relation to concession 3, I'm going to call it, the bit about trust returns and then the bit about the 5 years and 10 months, you accept that those bits apply only to concession 3, or could they apply to concession 2?
We would say that there is no reason for them not to apply to concession 2A just as much as they do to concession 2B/3.
Even though we then find the last part on 59 seems to be about concession 3.
Yes. We would say that this is not the best drafted document in the world. There are infelicities with it. But the fact that a document could be drafted better or differently doesn't, we say, mean that the words a similar concession don't apply to both parts of it. And that where there is repetition, it doesn't connote anything. Where there is something that specifically applies to only one, for instance, if it's talking about no credit will be given.
Can I just query that, whether that last paragraph does only apply to concession 3, because as we discussed this morning, concession 2 does include references to credit for UK tax.
Yes. That was not a concession on my part, forgive me the language.
Yeah.
What I was saying is that to the extent it is said that something is very specific to only 2B, it may be so read, but it doesn't mean that a similar concession doesn't import the relevant requirements from concession 1 into the whole of concession 2.
So just help me, how could that last part on 59 apply except in relation to concession 3?
My no credit will be given to tax creatures as paid. So if I look at 2A, so if you look at the second indent at the bottom of page 58, my lord,
Yes.
you will see may be treated as receiving the payment for a UK resident trust, but claim credit only for UK tax actually paid by. And so there is a credit reference within 2A.
So why do you need it then at the end of 59?
Again, we would say an abundance of caution.
Yeah, I see.
And those behind me have confirmed that it is, in 2A, I gather, it is to do with the payment of dividends. Yeah. So this would have been in relation to the tax credit that would have been payable in respect of dividends, I'm informed by those behind me.
Meaning the bit at the bottom of 58 and into 59?
Yes. But the draft, sorry, forgive me.
Go on.
No, I'm very happy to take the question.
I mean, on your case, with concession 3, You could have stopped, could you, after the reference to section 6871 ICTA, and the rest is superfluous.
A similar concession, we would say, would import all of that from the line above, except possibly the paragraph that deals with no credit, because I don't see a replication of that in concession 1.
Yes, I see.
But if I might just also make this point, that one of the points made by my learned friend. Forgive me. I think there was one final textual point, and then maybe if I move on
Yes.
to context and purpose, because I'm slightly conscious of the time. One of the issues that rose earlier was that there was a question about whether the requirement for the trustees to have made returns hardened up the concession, and we would say that nothing actually turns on that. One can read ESC B18 in 1978 as a requirement to submit returns. Now, whether one casts it in terms of the present continual or in terms of they must have made it or have made it, we say the implication is, an inference is the same, which is that in order to be able to claim this, those things have to have gone in. There need to have been relevant income tax certificates and the like.
Yeah.
And the reason we say that it's important in relation to non-resident trusts, and this is a context point, which is that, as I explained at the top, as it were, of the hour, the non-resident trusts are not chargeable on all income. They're not chargeable to UK tax on all income. It's UK source income only.
Yes.
And so the requirement for a claim, in order to get the benefit of this relief, carries with it not only reporting obligations, but compliance obligations. So the returns have to have gone in. Tax needs to have been paid. And this picks up a point my lady made earlier in the day. And that's a separate point, as it were, to enforcement. If there is a non-compliant, non-resident trustee, not that I'm saying it's true of this case at all, but were there to be a non-resident, non-compliant trustee, there would be difficulty in enforcing that. But the principled position is that the tax pool that arises in relation to UK resident trusts is a readily available source of information for the revenue to be able to check whether the tax has in fact been paid.
But also, much more fundamentally, there's an assessment under 687
Yes.
when they make the distribution. So there is an occurrence of charge then as well, which...
So there's an occurrence of charge, there's the creation of a tax pool. All of these make it, put the UK resident trust in a different position to a non-resident trust. And to the extent that any weight is being placed, if I may, this is slightly a linguistic issue again, but forgive me for this. If one goes to page 59 and the UK resident beneficiary of a non-resident trust, he may claim appropriate credit for tax actually paid by the trustees on income out of which the payment is made as if the payments out of UK income were from a UK resident trust and within section 6871. Now, as if here, we say, is doing no more than saying it's deemed to be as if it were deemed to be a payment from a UK resident trust. What it doesn't then go on to do is to say that the UK resident trust, the deemed UK resident trust, then has to pay UK tax, put money into, as it were, notionally into this tax pool, which is then available for credit. All of the 6872 consequences don't follow from the as if found it there.
So what is the point of the references to 687?
I think,
In
my lady, if I
concession
may,
3 and not in the bit of concession 2 that refers to credit and also treats the payment as from a UK resident trust.
and I think the answer, my lady, is this, that by referring to 687, what it is doing is giving more, the route by which the relief is going to be given, which is the credit mechanism. So it identifies that the manner in which the relief that is available under 2B or 3 as you wish is by using a credit mechanism.
But there is no equivalent reference to that in concession 2, that second sub-bullet.
Forgive me, my lady, I didn't catch the last.
At the bottom of page 58, we've looked at it briefly, going over to page 59, where it says may be treated, we're talking about non-resident beneficiaries here, may be treated as receiving that payment from a UK resident trust, claim credit only for UK tax actually paid. Now, the wording is very, very similar to that in concession 3, but without a reference to 687. And I must say I'm finding that quite difficult.
Yes, my lady. I can, again, what I would say is that the point to remember in relation to all of these concessions is that they're giving a relief. They, in relation to 2B or 3, it's saying that the manner in which it's going to be given is by trying to replicate a credit. So using the 687 type mechanism. 2A covers varieties of situations.
Yes, and it's more of a look, the rest of it is more of a look through.
And it may just be in felicitous drafting. I cannot give you anything greater, any greater guidance than this. And again, all I can do is reiterate the Greenwich property principle rule that actually this isn't statute. It's not had parliamentary scrutiny. It probably hasn't been drafted by Parliamentary Council. So to treat it, to pass it in the and put it under the cold scrutiny that we're doing today, needs to be done with an eye to that context.
Yes, but I think we're pressing on this because great reliance is placed on the references to 687 in concession 3.
And what we would say is all that they are doing is identifying, in the case of, by identifying 6872 in the opening words, is not within 6872. It's saying you're not a UK resident trust. So it's an identifier of the type, because that is what you see even in the earlier legislation, earlier iterations. It's identifying UK trusts and non-UK trusts as the sorts of trusts that come within the relevant statutory provision. Having done so, it doesn't then go on to identify it further by saying, look at it. Certainly this provision, 2A doesn't then go on to identify it any further, but 2B does. What more is to be made of it? We would say nothing. It doesn't carry the weight that it gives rise to an entirely different concession, which is not subject to the conditions to which the remaining concessions are subject. A similar concession is are the words that we rely on to import the same extent of relief, i.e. the 6-year limit. And it wouldn't be similar if, in fact, though it was unlimited in the number of years of income that were arising. Just standing back and checking it for sense, it wouldn't be a similar concession because the relief would be it would be significantly larger, potentially, depending on the number of years there was income, than there would be relief in relation to 2A or under 1. I think I've taken you through the context and purpose of section of ESC B18, and what we would say is that an ordinarily sophisticated taxpayer would look at this concession, look at the words a similar concession, would see that there are conditions that are imported and would apply it in that way. Because to apply it in a way that leaves out the 6-year limit from only B to B and not from 2A would be materially inconsistent as between the position of non-resident trusts and the two types of beneficiaries.
The trouble is that Mr. Massey says, on another view, it all fits. Because in the context of the statutory look-through, there is a 6-year limit. So you would expect the same to apply in the context of the non-statutory look-through. But when you come to 687, there is no 6-year limit. So if you're drawing the analogy with UK trusts and 687, well, why should there be a six-year limit? So it doesn't, to the ordinarily sophisticated taxpayer, look obviously anomalous.
And may I address that as follows? The line that runs through, the single thread that runs through all things from 18 onwards, all of which are alleviations, these are alleviations, is claim-based. Claims-based, not automatic. Therefore, there needs to be information, there needs to be compliance, there needs to be the ability to check.
But as Mr. Massey says, for any beneficiary to claim credit under 687, they've got to put in a tax return or a tax refund claim. They've got to fill in the details, including the identity of the trust, the amount, and so on. What is that if it's not a claim?
The point being that it needs to be possible for the revenue to be able to check whether it's correct.
But the same applies in that 687. You've got to identify the trust. You've got to persuade the revenue that you've received a distribution from a discretionary trust that fits within 687.
Exactly, my lady. And 687 applies to UK trusts and therefore is subject.
But it's still a claim.
It's it applies automatically. It doesn't have to be claimed. So it goes into presumably there's a box in the return. As far as I'm aware, but
I believe there is, but you still have to fill in the box.
Yes, but the point being that the treatment is automatic, as opposed to where you have to put in the information in order for the revenue then to check it. And in relation to non-resident trusts, where there isn't this readily available, ascertainable pool of tax capacity, that checking requires record keeping and is time consuming. And when one looks at MFK and the net cost question, it's entirely reasonable for the revenue to put in a 6-year limit. For 16, they put it in for for 18, they put it in for B1. It's incorporated into B2 by a similar concession, 2A, by my learned friend's admission. And we say it's incorporated equally into 2B. In fact, it would be surprising if 2B wasn't consistent with 2A and wasn't consistent with Section 18, because all of these are alleviations. All of them are seeking to ensure that the infelicities created by Section 16 when introduced are dealt with, are addressed. It doesn't perhaps cover every infelicity, but those that are covered are similarly treated, i.e. that the relief is available, and to the 6-year limit, 6-year income limit, we would say. You have our submissions in our skeleton argument about, we haven't resolved from any of those.
Yep.
So to the extent that I haven't, in the interest of time, gone into that it's a single concession, or that the headings were introduced by the judge, by the learned judge, for the ease of exposition, those are all points that we stand by and are in our submissions. This brings me to, and I will deal with the respondent's notice very briefly, because what we are not saying is that, let me start the other way. The concern created by the judgment of Mr. Justice Chamberlain was that it seemed, if I might start with settled practice, it seemed to require the revenue to periodically issue statements of how they applied ESCs at any given time. Because otherwise there wouldn't be information in the public domain which would be something that an ordinarily sophisticated taxpayer could take into account. And we say that if that is what has been, if that is a consequence of Mr. Justice Chamberlain's decision, then that creates difficulties for the revenue. Not least because ESCs are published practice, but there's guidance which contains practice. There are booklets that contain practice. So from time to time, is it expected that the revenue puts out statements about how it has applied that practice? And we say conceptually that's rather difficult because if the revenue has decided that it is no longer going to follow a practice, the most natural thing for the revenue to do is to actually withdraw that practice or to resile from it, making a statement with adequate notice. Practically, we would say it's also difficult because what it requires is for every single extra statutory concession or published practice or actual practice, which is known to some but not necessarily to others or is set out in commentaries, the revenue would have to periodically write a press release to say, and in relation to this, no challenges, in relation to this, no challenges. That's asking, we would say, putting an onerous burden on the revenue in the duty it has of collection and management. That was our short point on settled practice. There was nothing more being made of it.
Okay, so it's really a point about the wider implications of
Yes.
the judgment rather than a point that really affects
Yes.
the result in this case.
Yes, my lady, and we have to keep an eye on
Of
that
course,
yes.
because it is part of the wide managerial discretion to make sure that the revenue can actually efficiently collect the tax that needs collecting. The next point, again, is a broader question about what is it. So again, it's not something that we say jumps out from the documents that we have before you, but it's what is it that an ordinarily sophisticated taxpayer would know, and what materials would he be entitled to consider, or which are in the public domain. And we say that within those, you do have things like the revenue manuals, you do have HMRC 6, you do have IR 35. All of these documents are in the public domain. An ordinarily sophisticated taxpayer would certainly, we would say, be aware of them and look at them. What he got out of them, of course, is a matter for conjecture in this context.
Okay.
So again, your concern is really the wider picture
Yes.
rather than anything we'll find in the materials in this case.
Absolutely, Madam.
Yes,
Absolutely. To the extent that it is said that commentaries are not useful as a source, the reason we put in commentaries, or put in that commentaries are something that ought to be considered relevant to what an ordinary sophisticated taxpayer would be aware of, is that commentaries do sometimes cover things like ESCs, do cover practice. You know, so the point is that, again, a wider point. As it
Okay, so for example, if a commentary had clearly said the revenue practice, settled practice since the year dot, as known by most practitioners, is as follows, and that was pertinent, you would say that might be part of the relevant context.
well, that would be something that an ordinarily sophisticated taxpayer would
So
look
again, it's this wider picture, not
Yes.
making a difference on the facts.
Yes.
Okay.
As it happens, I gather that in 2016, it's not in the bundle because it isn't before you, but some parts of TSEM, which is the Trusts and Settlements Estate I think it's Estate Manual, were referred to by Mr. Rimmer. They were before the judge. And I do have a reference for you. So it isn't the case that we didn't actually refer to TSEM before. The only reason we've put it as part of the skeleton argument is not to make a point that is a slam dunk in this case. It is to say commentaries do cover wide things. They do cover things like revenue practice. So it isn't the case that the revenues practice is always only known to itself. So the blanket sort of statement that 61 and 62 seem to create is one that has caused us a certain concern.
I see that. What is implied in what you're saying is that the meaning of a concession can change over time. before a commentary is published, the ordinarily sophisticated taxpayer might read it one way, but once a commentary is published, he might read it a different way.
I think the point I'm making, my lord, is that if context is relevant, and we know context is relevant, one needs to have regard to the full context. And the full context will involve the point at which the person is asking this question. It can't be, as it were, frozen in aspic to just when the document was published. In that sense, it is different to the sorts of cases that talk about later legislation dealing with earlier legislation. It's qualitatively different. What we're looking at is the words on a page. How are those words to be interpreted? Well, an ordinarily sophisticated taxpayer would have available to him the full tools and the full basis of research, we say, which would include matters that post-date the existence of that. I mean, if a case had been decided, for instance, following the...
Yes, that is right, in a rather different category, though, to this is the revenue's interpretation.
No, absolutely. And it would be no more than an interpretation, but it would be material that is there.
Mm.
I mean, I can quite see, you may say, well, that's fair enough. This is only ever a concession. It's not statute. There's no statutory entitlement to any of this stuff. What's wrong with saying that the concession can change its meaning over time if that fits with the revenue's intentions that you can see from their manuals or from commentaries or whatever? But it is implicit in your case that the meaning can change over time, I think.
I think it has to follow from the fact that one looks at an ordinary sophisticated taxpayer at the point at which he's asking the question.
Yes.
That the materials available to him or her at that point would be relevant. Are they determinative? Of course not. But they are the things that an ordinarily sophisticated taxpayer would use as tools to understand what these words mean.
Yes.
My lord, I would like to deal briefly, I think, with the EU point.
Yes.
Again, this poor ordinarily sophisticated taxpayer is required to jump through extraordinary hoops in order to understand his position. We say, just looking at the words, a similar concession will apply, will operate, requires very little jumping through hoops. You give weight to the word similar, you give weight to the word concession. You understand concession to mean the relief, and everything flows from that. Our thesis is very straightforward. It doesn't require looking at other statute in order to be able to, as it were, pull to be up by its bootstraps to mean something that on its natural reading it doesn't mean. It's not a UK resident trust that is concerned. The deeming as if doesn't mean that a tax pool arises. It doesn't deal with the concerns that arise with having a non-checkable claim being made. So an ordinarily sophisticated taxpayer, we say, would be aware of all of this. What would he be aware of in relation to EU law? And my learned friends have put it in terms that he would know that payments from non-resident trusts are being treated differently to payments from UK resident trusts. And we would say that an ordinarily sophisticated taxpayer would, to the extent he knew about EU law, would know about EU law as it properly applies, as it correctly applies. And he would realise there are varieties of payments that come out of UK resident trusts. In this case, they were retirement benefit schemes payments. So they were taxed as employment income. That's not necessarily the case with other payments from trusts, which might simply be payments to beneficiaries, which are annual payments. So to say that baldly payments from UK trusts are being treated differently to payments from non-UK trusts is, we say, something an ordinarily sophisticated taxpayer would know was too simplistic a view. The correct EU position is much more complex than that. You look first, I mean, there's a wealth of case law. You look first at the legislation, or in this case, ESC, there's a bit of debate about whether or not, in fact, one can challenge practice by way of EU law, but I'm going to leave that to one side. That's quite a complex area. But what the ordinary sophisticated taxpayer has to work out is what is it that's covered by this relevant practice. This ESC covers all types of payment. It could cover investment income, it could cover employment income. So looking at just the thing that is being challenged, the executive fiat that's being challenged in this case, he wouldn't necessarily know which freedom is engaged. But assuming that, say, two freedoms were engaged, say freedom of capital, free movement of capital was engaged, and free movement of workers was engaged. This, after all, was an employment payment and was paid, and PAY was operated in relation to it. There is case law, and I've set it out in our skeleton argument, so I won't trouble you with it unless you want me to. Fidium finance is the principal one, which requires you to work out which freedom is the one most closely associated with the payment that's being made. So if it's remuneration for services, but there's a transfer of money, which engages the free movement of capital, it's only a remuneration for services. So the principle, the most closely associated freedom, is that of workers. Workers, or in fact services, depending on the type of service. What these cases, Fidium Finance, Société Générale, and it'll come to me, state is that you have to determine which is the predominant freedom, and then you don't turn to give free movement of capital independent analysis. So that, and the only freedom upon which a Guernsey resident trust can rely is free movement of capital, because it's a third country.
I'm not sure that matters, though, because the ordinarily sophisticated taxpayer is going to know that this document doesn't just apply to Guernsey, it applies across the board. So he'll think to himself, I've got to think about how it is to be construed, not merely as it would apply to Guernsey, but as it would apply to France or Germany, or indeed some other country outside the EU.
And the point I'm seeking to make, my lord, is that the ordinary sophisticated taxpayer would need to know that where the legislation itself doesn't identify clearly which freedom is engaged, you have to then turn to the facts. So he would have to postulate facts and then work. There's quite a process that he would have to go through before he could decide that there was in fact discrimination.
Well, would he? I mean, all he has to do is think, is there a situation, or are there obvious situations where EU law would be engaged and on the face of it breached? He doesn't have to say that, work through every possible situation and work out how it would be classified. He might, for example, as I think Mr. Elliott was rather suggesting, say, well, you know, if you've got a trust that wants to move to France, a freedom of establishment is engaged, and plainly the differential treatment, which on the Romney's case applies, could be such as to dissuade somebody from moving to Germany. Therefore, there is on the face of it a breach of EU law. That can't have been intended. Therefore, the revenue's interpretation must be wrong. He doesn't have to work through every possible scenario and work out which freedom would be engaged in every situation.
We would say that if you were to do so, he wouldn't be doing so consistently with the EU law. And I think we have to assume that the ordinarily sophisticated taxpayer is going to apply the law properly. And EU law cannot be applied in this very broad brush way. It is very person and fact specific because of the inquiry that needs to be made. So to stand back and say all non-resident trusts are being treated differently to all UK resident trusts, and therefore there is discrimination, is not, we would say, a correct application of the law. And in our respectful submission, an ordinarily sophisticated taxpayer must be assumed to apply the law correctly.
Can the ordinarily sophisticated taxpayer conclude that where there's a question of a trust moving to France, EU law won't be engaged?
If he went through all the hoops, and it in fact was employment income, and it's France, forgive me. So if he were to say the facts are that it's what's an ordinary everyday trust. Beneficiary is not an employment trust. So it would be freedom of establishment.
Freedom of establishment is the obvious one, isn't it?
Yeah. So in that scenario, and it's in France, so in theory, it's you can engage freedom of establishment. He would then have to show that the payment was in fact not a payment that is properly to be regarded as any other sort of payment. So it might be that free movement of capital is the predominant one because it's not an interest that has definitive control. Is that the phrase?
But even then, that doesn't help either, because if in such a situation you're dealing with free movement of capital, why does that help? You still got a freedom.
Whichever freedom the sophisticated taxpayer drills down to and discovers is the predominant one, you then have to ask the $64,000 question, which is, would this dissuade the trust from establishing itself in France, in the example that you've got, because it would mean that the trust beneficiaries were worse off than if the trust stayed in the UK? It's a simple question, and the answer to it is yes, they would be worse off. On your analysis, but they wouldn't on the other.
That may be the factual outcome, but the question is this discriminatory, which is a legal question? And what I'm seeking to try and do here is to say that it's not something that is amenable to a hypothetical thought process. It depends. It needs, and also in this case,
it has to be hypothetical if you are construing something. It can't be fact specific if you are looking at something that applies across the board, because you can't cover every possible permutation of fact. But if the principle applies as a matter of potential construction, I can see why you might say it didn't. But if it applies as a matter of construction, then I'm afraid you can't give it the degree of particularity that you're seeking to urge on us.
And my lady, what I would say is because of the fact that it needs to be analysed with a degree of particularity, it is not, therefore, an appropriate matter for which an ordinarily sophisticated taxpayer ought to take into account, because it isn't something that is amenable to a hypothetical answer.
Suppose you're wrong about that. What's the answer to the point that Mr. Massey makes?
Forgive me, that it is discriminatory, is that?
Yeah.
Well, it is different treatment, isn't it? So,
and it is potentially likely to dissuade somebody from establishing themselves in France, isn't it?
I'm just looking to those behind me, my lady.
Yes.
So those behind me have reminded me that even if it were to be, so what is the outcome were it to be held to be discriminatory? There would need to be conforming construction. Assuming all of this can apply to a practice, what is the way in which to conformingly construe this?
I think Mr. Massey says, well, that was the judge's concern, but that's an irrelevant concern, because we're not concerned with adopting a conforming construction. The question is rather, when the ordinarily sophisticated taxpayer looks at this document, he says, how should it be construed? Well, the revenue can't have meant to produce a breach of EU law. Right. Therefore, it must mean what Mr. Massey says. So it's not a matter of adopting a conforming construction, it's just construing the document by conventional principles in the context. You conclude that it has a meaning that actually is consistent with EU law.
My lord and my ladies, with respect, you're pushing me beyond my instructions on this point. My instructions are that there is given the particularity with which the EU point has to be determined, it cannot be something that is appropriate to deal with in the context of a hypothetical, ordinarily sophisticated taxpayer.
So you never get to the stage where the taxpayer would say to himself, well, there's a prospect on one reading of this that the revenue could end up in difficult waters in terms of EU law, because they might be held to have discriminated against somebody, whereas on the other straightforward construction, they would never be exposed to that risk. But I can't take any of that into account in deciding what the revenue intended.
To that, I might say this, my lady, which is that the treatment which gives rise to this difficulty doesn't start with the ESC B18. It's actually a legislative treatment, and the forum for that is not this forum. The forum for that is the FTT, and those sorts of debates are best dealt with in the FTT and not here. I cannot, I believe, assist you any further on that point.
Yes, I see.
Okay. I did want to just, there was just one point which I referred to the cases, and I said another one, there's
Yes.
a couple more that I meant to mention. There's Finnecane, again, it's in our skeleton argument, but it's at tab 30, and there's Kronos. Forgive me, I gather it's not in our skeleton. In relation to Finnecane, if I could just give you the passages that need to be borne in mind, just for your note. Finnecane, it's paragraphs 39 to 43.
Of the judgment.
Of the judgment. I didn't refer to the Advocate General, although I think they are there within the bundle. And in Kronos, it's 30 to 32 and 36 to 37.
Yeah.
We had, in the interests of giving you the latest up-to-date versions of Bennion, printed off some Bennion, which actually mentions Murphy below, but we have it with us. I don't know if you want to be showered with more documents.
I think we may have that already.
Oh, do you
Got
have that
something
already?
from Bennion here.
Okay,
That's
yeah.
well,
thanks,
it's
Sarah.
there for you should you wish to look at it. If there's anything else, my ladies.
Extremely helpful, thank you.
Thank you.
Thank you very much, Ms. Nathan. Mr. Massey.
Well, I'm going to hope to not to be very long.
No.
There's been a sort of plethora of points which I've been sort of jotting down. Some may have been more important than others, which actually I haven't grasped. But if there are points which you would like me to grasp rather better and give an answer on, no objection to that. But just going in the order of the points that I have taken on board. One is I think Madeleine Rome said that a non-resident trust has no tax pool and therefore is to be distinguished from a UK resident trust. The tax pool isn't a term of art, and certainly wasn't a term of art in the 1999 time of the 1999 concession. It's actually come in as a defined term in the Income Tax Act 2007, which has the successor legislation, Section 494 of the Income Tax Act 2007. So the draftsman has now, the statutory draftsman has now used the tax pool. There's no such thing as tax pool. And all tax pool means is basically what is in Section 6873 of ICTA. So it's basically all of the amounts listed in Section 683, which are tax, forms of tax paid by the trustee. And the main one is, of course, income tax paid on trust income. That's the ordinary one. There are various limitations to what amounts can be taken into the tax pool, and for example, tax on dividends is one of the limitations. It's actually in the authorities bundle. I don't really want to go into it because it's quite a complicated point. But the provisions, I think it's tab 5, which has the yellow book for 96, the yellow book for 1994, 95. Tab 6 is there for 1999, 2000. But if you look at 6873, little double A, little double A is the amount of tax which, by virtue of section 2331B, I'm sorry to say that's also in the bundle, you need to look at it, is charged at a rate equal to the difference between the lower rate and the rate applicable to trusts on the amount or value of the whole or part of any non-qualifying distribution, including the income arising to the trustees. Unpacking that, a non-qualifying distribution will be a dividend from a company. And
actually only certain types of distributions.
And only certain types of distribution.
Yes, it's highly complex, this. Is this
quite
really going to help us?
And one needs to put a coal tar around the head before you get looking at section 2331A. But there are some types of income where the trustees don't get the entire deemed tax as part of the pool, and dividends is one of them. Foreign income dividends was also one of them, and that's also in the case one's good. But there are certain types of there are certain types, for example, of tax credit which are not repayable, and that is what is being looked at in the final paragraph of ESC B18. That recognises there are some types of tax that are not dividend tax credit, for example, parts of which are not repayable, and so but that is the tax pool. In 1999, it was a slang term. It's what one used to mean section 6873 payments. It just meant the term tax capacity was the term the judge used, which was a rather good term. Section 673. Now, concession 3 is, of course, keen. Not really keen. I mean, it requires you to determine the tax capacity of the foreign trustee, because the tax credit that the beneficiary can get from the credit mechanism cannot be above the tax capacity of the trustee, and that's why it's relevant. And that's actually why the draftsman of the concession, who added the words "and within section 6871" of the ICTA, must have done so intentionally, because if one looks at section 6871, the effect of that is to, and it's at page 62. 6871 says the following provisions of this section shall apply with respect to the payment. So, by saying the payment is within section 6871, it is basically saying that you get the treatment of what follows from being a payment within section 6871. So that involves section 682, which is the credit mechanism, and the and in terms of the tax actually paid by the trustee, which is quoted in the concession, that is very similar to the tax pool. It doesn't actually matter whether you call it the tax pool or not, or indeed whether it's the statutory tax pool. It is the tax paid on the UK source income by the trustee.
Yes, but the mechanism is very different, isn't it? 6872 doesn't apply. You've not got an assessment on the trustees with that tax being imputed to the beneficiaries.
No.
Rather, the effect of the concession is to impute tax credit for the tax that's been paid underlying that. There isn't any express reference to 6873.
There isn't an express reference. There isn't an express reference to 6873 or indeed 6872. It's section 6871, which in my submission, as it were, unlocks the provisions of section 687 that follow that. Simply because all section 6871 does is to say that any payment that's within section 6871 has the following treatment. Nothing actually happens itself under 6871. It's the treatment that you get, which, as it said, if you're told to be, if you're treated as if the income is paid from a UK, payment is made from a UK resident trust, and as being within section 6871, that puts the, in my submission, that puts the UK resident beneficiary in the same position as he would have been if he had in fact been a beneficiary UK resident trust, except for the fact that there is this limitation to his tax credit, so that instead of being able to say under section 6872, my payment of 10 million has to be treated as a payment of 18 million, and I'm entitled to a tax credit back of 8 million. If he were actually a UK resident trust and the trustee had only paid 6 million of tax, there would be an assessment on the trustee of that 2 million. And what the concession does is to say, well, we know it's going to be difficult to go after a non-resident trust, so we'll just cap the credit under section 68, under section 687 at the level of the tax that he's actually paid, the trustee has actually paid on the income out of which the payment is made.
And it's not merely that it's going to be difficult to assess the trustees, they are not assessable.
They're not assessable because of the limit that's imposed. If the credit treated as being available to the individual is only up to the tax capacity, he can have his payment grossed up, but no higher than the amount which would prevent, which would allow all of the past tax to be offset under 687. So in effect, and I'm sure the reason is to prevent the need to go after the non-resident trustee. So it's not complete section 687 treatment, but it's section 687 treatment, which with that limitation.
And that cap is by something that amounts to, you say, something equivalent to the tax pool.
It is. I mean, the tax actually paid on the UK source income is the tax pool.
Yeah.
I mean, it's what you and I would understand as the tax pool, the tax capacity.
Just proceeding a moment longer irrelevantly. I mean, even if the concession had said, and the trustees shall be liable, that couldn't work, could it? Because that would not be in a statute, and the concession could not impose a charge on the trustee.
That's right. I think that's absolutely right. Yes. Right. My Lord, the next point is this question that I raised this morning of why the changes in the 1999 concession, not only the formatting changes and division of paragraphs, which in my submission are important and were obviously considered, but the words "and within section 687" in concession 3, as Lady Justice Falk has said, but not in concession 2. And the answer comes back, oh, well, it's just infelicis drafting. The draftsman didn't give it any thought.
Surplusage, I think, is the way it was put.
Sorry.
Surplusage, I think, was the way.
Surplusage. This must have been a very, very, it's a very important statement to put in and within section 687 when it wasn't there before, and to put it in only in relation to concession 3 and not to concession 2 must have been given a great deal of thought, and no doubt the draftsman was very carefully directed on it. The we have to remember this is the third iteration of ESC B18. They started in 1978, again in 1994. We're only 5 years later from 1994, and yes, a very careful consideration was given to the wording in 1999, and one cannot say that the fact that concession 2 didn't have a within 1978 and concession 3 did is accident or infelicitous drafting. It's not possible. Well, it's certainly not something that the ordinarily sophisticated taxpayer would regard as surplusage. It's vital. My Lord, can an extra statutory concession meaning change over time? And I understood my learned friend to say, well, it can change, it could change after a revelation of what the revenue thought in public, in manuals, for example. In my submission, that can't be accepted, really for the reason that is given in the Cameron case, in the quote that we went through just before, or just after the short adjournment, that it isn't up to the revenue to be the arbiter of the concession. The concession is a public document. It's up to the courts to interpret it. It can't change its meaning by somebody in the revenue putting in manuals. And the Cameron case makes clear that if the revenue want to change a concession, they can of course do it. They can withdraw the concession and reissue it on different terms. But simply saying this is what ESC B18 means in a manual can't change its meaning. And my own friend was concerned that it's the same point really, that settled practice concerned that settled practice to issue statements as to how they apply the ESCs at a given time. It would be administrative inconvenience to be having to do that. In my submission, even if they did it, it wouldn't change the meaning. So I think that needn't be a concern of that. It would just be a pointless thing to do. I mean, certainly in terms of law, the revenue very commonly set out what their interpretation of legal provisions is. That is obviously very helpful to taxpayers, and long may it last. But as far as changing the law, you can't do it. So it is really a case of what it means is what it says. The accenture. My learned friend suggested there was a difference in terms of claim between the statutory section 687 beneficiary and the non-statutory ESC B18 beneficiary. It's really a case of repeating my earlier submission that that there is a claim involved in both. I believe that there is a form, SA 107, which is the add-on form if you're a beneficiary of a discretionary trust and receive a payment. You put that payment in and you put in the net sum, the net sum will obviously be grossed up and you've got your tax credit from that. In order to get it, you've got to claim it somehow. It's not enough just to have a tax credit. You must claim it. And every tax credit involves a claim. And it may be that in a self-assessment case, that claim will be on the self-assessment. But of course, there are certain times when the beneficiary won't even be a taxpayer, won't even be a self-assessing taxpayer, who would have to put in that claim on a completely different form, a completely new form. And I believe, I won't say, I think it is right that an ESC B18 beneficiary can put in their claim on the SA 107 form in exactly the same way as a statutory. Section 687 payee. It's not an important point. My learned friend, I think, attributed to me another new point. My learned friend attributed to me an acceptance of the position that a similar concession in the 1994 ESC imported the 6-year limitation into the credit mechanism in 1994. I don't
think she said that.
Oh, I'm delighted if she did, but I certainly don't.
I think she was saying that you, well, I'm probably getting it wrong, but what I've understood the position to be, and I don't think Ms. Nathan said otherwise, was that it's your case that in relation to concession 2, as you would term it, the similar concession brings in the 6-year limit. Indeed. And I don't think Ms. Nathan is disagreeing with that.
Not the second, not exactly, not the credit mechanism. Although I recognise that, the 1994 concession was not very felicitously drafted. I think one could say that, and was. I mean, I think that in itself is probably reason to think that the 1999 version would have been very carefully.
We obviously haven't given you very long to reply.
No.
At the same time, we are up against the time limit.
We are against the time limit. I mean, there's very little that I have sort of jotted down as things that I'm able to answer. I think there's not a great deal more, but if I can.
I think Mr. Elliott has a point for you.
Yes, yes, I'm grateful to know. One of the points which we said was this statement in the Greenwich case, where it was said, well, if there is ambiguity, you can always ask the revenue. And okay, that is true. There's ambiguity, always ask the revenue. But the problem is, you may get a wrong answer to the question you asked. It's not a case of ask the revenue only in cases of ambiguity. You may be completely convinced that your interpretation is right, but want to check it. And if you get a wrong answer, Greenwich doesn't say you're bound by that wrong answer. It is pretty obvious, as the Cameron case says, that you are bound. You aren't bound by that answer. So, really, just to round off, we do say that the plain meaning interpretation is the correct interpretation. Concession 3 does carry 3 out of the 4 conditions that are sent out verbatim in concession 1, but not the 4th. Does that surprise one? Not at all. The credit mechanism had no 6-year limitation, and that is a completely standalone concession. That is the right interpretation in terms of context, text, all the guides to normal interpretation of a document, paragraphing. That is the right interpretation. And in my submission, the alternative construction, which Justice Chamberlain found, was not not a possible interpretation for the normally sophisticated, ordinarily sophisticated observer. And the fact he found it doesn't mean it's ambiguous, simply in my submission. And although there's my submission, I don't know whether my learned junior, who I know was scribbling while the EU point, whether he has anything to add. I'm sure your lordship is hoping no, but...
You may be right in that belief, Mr. Massey, but let me just see whether Mr. Elliott does want to add anything.
Well, may I have 30 seconds? And the sticking point seems to be whether the ordinary sophisticated taxpayer can look at hypothetical facts. And the answer to that is the exercise has to be hypothetical, because we're dealing with a notional ordinary sophisticated taxpayer. They don't have any facts. And that exercise of looking at different fact patterns is a very natural exercise for any reader. You would do it quite naturally if you were looking at a statute or a contract. You test different interpretations through obvious fact patterns, see which one is the most likely to be correct. So it's just an extension of that. It's a natural reading and interpretation of a document. And then final point, HMRC, firstly, they're not disputing their interpretation gives rise to discrimination. And secondly, this litigation has been going on for a number of years now, and they still cannot provide a justification for that discrimination. Unless I can give any further assistance.
No, I don't detect any more questions. In which case, thank you all, those with speaking roles and also those who haven't had speaking roles, very much for your assistance. You will not be surprised to know that we are reserving our judgment. In accordance with what is now the practice, you'll receive, the handout will be remote, but you of course will receive the draft beforehand for you to correct our typing and similar things, but not of course to re-argue the case. We'd be grateful if in advance of the hand-down you seek to agree between you an order dealing with consequential matters. If there are points on which you disagree, we would be grateful for brief written submissions, again in advance of the hand-down, and we'll settle the points, or would expect to settle the points in the order that we make. I'm sure that you're all very well aware of the Counsel General for Wales case and the emphasis on the need for compliance with the confidentiality that will apply once you get the draft judgment. So please ensure that that obligation is indeed complied with. But thank you all very much.
All right.